Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. So today I am going to finish up my little part on due process. And today we're going to talk specifically about the issue of notice. And here's what I'm going to do. I'm going to do this in as apolitical a way as I can, but I am going to go through all of the law with relation to indictments and what they must contain. I will go through some of the cases and what they say about indictments and the issue of notice. And then we'll take a look at the indictment of former President Trump in New York. We'll take a look at the jury instructions. And then you guys get to tell me what you think about whether the process was fair, whether it comports with due process, and what you might think if you were sitting on an appellate court. So with that intro, let's get into this. The other day I went through the historical underpinnings of due process. Now I want to drill down a little bit on this idea of notice. As you know, due process includes the right to notice of the charges and the right to a fair hearing on those charges. Today we're looking at the notice requirement of due process specifically in terms of the criminal law. The main way that a defendant receives notice of what the state says he or she did is to read the indictment, which is the penmanship of the DA but the work of the grand jury. Here is how one author explains the purposes of an indictment or a complaint that provides the notice. The charging document is intended to serve 5 purposes. First, notice. The charge gives the defendant notice both of the alleged facts and of the prosecution's basic legal theory. A deficient charge may deprive the defendant of the opportunity to prepare his defense. Judicial review. The requirement that the charging document allege every essential element of the offense permits the defendant to test the sufficiency of the prosecution's legal theory by moving to dismiss the charge. If successful, this avoids an unnecessary trial. In any event, the requirement gives the parties a common legal framework to guide the presentation of evidence at trial. Grand jury. In cases prosecuted by indictment, the indictment must demonstrate that the grand jury voted on the essential elements of the offense and agreed that those elements were satisfied. Otherwise, prosecutors could frustrate the right to indictment by filling in elements of the case with facts other than those considered by the grand jury. Double jeopardy. A charge must be framed specifically enough to enable the defendant to plead double jeopardy if re-prosecuted for the same offense. Jurisdiction. Due process requires the pleading to allege all of the essential elements of the offense in order to establish the trial court's jurisdiction to punish the defendant. Notice is important to the defense because they need to know what the state is going to try to prove and the facts the state feels constitute a crime. That's why a criminal defendant has the right to notice of charges against him. That right is grounded in the Constitution. The accused shall enjoy the right to be informed of the nature and cause of the accusation. However, the requirement of the Sixth Amendment is binding on the states under the 14th Amendment's due process guarantee. No principle of procedural due process is more clearly established than that notice of the specific charge and a chance to be heard in a trial of the issues raised by that charge, if desired, are among the constitutional rights of every accused in a criminal proceeding in all courts, state or federal. That quote is from Cole v. Arkansas, a 1948 case from the Supreme Court. Notice of issues to be resolved by the adversary process is a fundamental characteristic of a fair procedure. That's Lankford v. Idaho, 500 U.S. 110, which is a 1991 case from the Supreme Court. Notice is an important part of due process, and it has a long history in American law. Hamling v. United States, 418 U.S. 87, said this: "Our prior cases indicate that an indictment is sufficient if it, first, contains the elements of the offense charge, and fairly informs the defendant of the charge against which he must defend. And second, enables him to plead an acquittal or a conviction in a bar to future prosecutions for the same offense. So let me break that down for you. If you are acquitted, you can never be charged again with that crime. If you are convicted, you can't be charged with that crime again either, which only makes sense. But if the indictment is not specific, it's possible for you to be charged with something that was done at the same time in the same way, in the same criminal enterprise, and you could be charged for it if the indictment is not specific. It is generally sufficient that an indictment set forth the offense in the words of the statute itself, as long as those words of themselves fully, directly, and expressly, without any uncertainty or ambiguity, set forth all of the elements necessary to constitute the offense intended to be punished. That's United States v. Carl, 105 U.S. 611, an 1882 case. Other Supreme Court cases have said this a little differently. Apprendi v. New Jersey, 530 U.S. 466, a 2000 case. At stake in this case are constitutional protections of surpassing importance, the prescription of any deprivation of liberty without due process of law, and the guarantee that in all criminal prosecutions the accused shall enjoy the right to a speedy and public trial by an impartial jury. Taken together, these rights indisputably entitle a criminal defendant to a jury determination that the person is guilty of every element of the crime with which he is charged beyond a reasonable doubt. That's from United States v. Gaudin, and the Apprendi court quoted it. The Due Process Clause protects the accused against conviction except upon proof beyond a reasonable doubt of every fact necessary to constitute the crime with which he is charged. Reciting the history, the Supreme Court has said, in years past, as a general rule at the founding of the country, criminal proceedings were submitted to a jury after being initiated by an indictment containing all the facts and circumstances which constitute the offense, stated with such certainty and precision that the defendant may be enabled to determine the species of offense they constitute in order that he may prepare his defense accordingly, and that there may be no doubt as to the judgment which should be given if the defendant be convicted. The defendant's ability to predict with certainty the judgment from the face of the felony indictment flowed from the linkage between the punishment and the crime. So to be clear, the indictment must set forth every element of the crime. It must do so with particularity. It must enable the defendant on either conviction or acquittal to assert that judgment against any further trial on any of those elements. Now, different states have handled this differently, and for the last 20 years or so, one of the key issues in the notice area has been on sentencing enhancements. In People v. Hernandez, which is a case out of California, the defendant was charged with kidnapping and another crime, and the probation report for the first time recommended the imposition of an enhancement because the kidnapping was for the purpose of committing the other crime. The trial court agreed with the prosecutor that this was just a sentencing fact and imposed the enhancement. The California Supreme Court reversed, ruling that the lack of a pleading and proof requirement in the law was a legislative oversight. It held the enhancement must be pled and the predicate facts for the enhancement proven. Due process requires that an accused be advised of the specific charges against him so that he may adequately prepare his defense. Furthermore, the court rejected the Attorney General's argument that the error was harmless since the defendant received no notice of the penal code section involved, nor of the mens rea required by the section of the penal code. As a matter of due process, the enhancement could not be imposed. So one way to assess the importance of notice in criminal charges is to look at what the Criminal Resource Manual of the Department of Justice says. Now, the Criminal Resource Manual from the Department of Justice is available online. The current version is not available, but the past version is available in the archive, and you can get to it and you can read it. And here's what it says about the sufficiency of an indictment. The Federal Rules of Criminal Procedure requires indictments to provide a plain, concise, and definite written statement of the essential facts constituting the offense charged. The Supreme Court has instructed that an indictment is sufficient if it contains the elements of the offense charged, fairly informs the defendant of the charges which he must defend, and enables him to enter a plea without fear of double jeopardy. And they cite the Hamling case. The sufficiency of an indictment is to be measured by certain guidelines. First, the indictment standing alone must contain the elements of the offense, and it must be sufficient to apprise the accused of the nature of the offense. Second, after conviction, the record of the case must be sufficient so that the accused can plead the judgment in bar of any subsequent prosecution for the same offense. So, for example, in a mail fraud or wire fraud indictment, it should contain reasonably detailed description of the particular scheme the defendant is charged with to ensure that the defendant has sufficient notice of the nature of the offense. Now, remember back to what I said earlier about the indictment must set forth every element of the crime. It has to do so with some particularity, and it must enable the defendant on either conviction or acquittal to assert that judgment against any further trial on any of those elements. Well, here is the indictment of Donald Trump in New York. And they go through the information there about the grand jury and falsifying business records in the first degree. It says the defendant, with the intent to defraud, intent to commit another crime, aid and conceal the commission thereof, made and caused a false entry in the business records of an enterprise, to wit, an invoice from Michael Cohen. So then we go down to the second count, and the second count says pretty much the same thing. Basically, every one of these counts is exactly the same. And it identifies the penal law, 175.10. And that's important to keep in mind because 175.10 is the actual penal statute involved. Now, here's what's the problem with this indictment. It says intent to commit another crime and aid and conceal the commission thereof. But it doesn't name what that other crime is, and that is not fair notice. Now, how do I know that? Well, let me explain. This is the jury instructions that were given to the jury in New York, and I will omit all of the precatory information because it doesn't really apply here. The judge says, I will now instruct you on the law applicable to the charged offense, falsifying business records in the first degree. It's penal law 175.10, right there, right? So he goes through all of the information about the 175.10, intent to defraud, intent to commit or conceal another crime. Under our law, although the people must prove an intent to commit another crime or aid and conceal the commission thereof, they need not prove that the other crime was in fact committed, aided, or concealed. But then we come down to the laws that were supposedly broken or concealed. Here is 17.152, predicate offense, New York election law. Okay? And then we get to Federal Election Campaign Act, and falsification of other business records, and violation of tax laws. Here's the problem with the Trump indictment compared to the jury instructions. The indictment provides no notice that the state was going to rely on the election law. It provided no notice that they were going to rely on the Federal Election Commission violations. It provided no notice that they were going to rely on the tax code. Now you have all of the law on the issue of notice as it relates to an indictment for something like a crime of the nature that Donald Trump was eventually convicted of. So the question is, did the indictment set forth all of the elements of the crime charged? Did it set out the predicate offenses, the things like the Federal Election Commission Act, the New York election laws, covering up another business record. Any of those things, were those set out in the indictment? Was each count specific to a specific predicate offense? You might consider what the purpose was in omitting the predicate offenses. Was there a strategic or tactical reason that that was done? And if so, does that violate due process? And finally, did the jury instructions match up with the indictment? Now, if you conclude that there was fair notice, I would love to hear your explanation for why that is. And if you conclude that there was not fair notice, again, I would love to hear what you think the key facts are that drive that decision. This is an important issue. The people who are watching this video probably know more at this point about due process and the issue of notice in due process than 98% of the people who have watched or participated in that trial. And the reason that is because we don't do a very good job of explaining how our law works when you're coming up through high school and even in college. We just don't do a good job of that. And as a result, people think, well, the government put the indictment out there and the judge said the indictment was okay, so it must have been okay. But obviously, if everything judges did was spot on, we wouldn't need appellate courts. And here, the appellate court is going to be asked to look at, among other things, the indictment, the violations of constitutional due process, the due process clause, both from a procedural standpoint and from a substantive standpoint. It's going to be asked to look at the jury instructions in this case. I plan to do another video with respect to the jury instructions in the case. But essentially, I'm asking you, my great group of people who watch these videos, to tell me what you think. And maybe we'll do a video where we go through some of your analysis and some of your opinions on this case. The only thing I would ask is that if you have comments, please try and keep them civil. It is okay to have a disagreement. It's not okay to be rude or to use words that are profane or obscene or anything like that. If you have those kind of comments that you want to make, or you want to tell me that I am one of those things, or ask me to perform an act that is anatomically impossible, that's fine. Send me an email. I don't mind. I look at all the email and I laugh at a lot of it because some of it is really good and some of it is people who just really don't understand the way our country works and the way a republic is supposed to work. But that's okay. That's what I'm here for. I'm here to explain. I am really looking forward to seeing your comments. Please make sure to leave a like and subscribe if you haven't already. And again, thank you for watching this video. If you would, take a moment today and do a kindness for someone. If you go out to dinner tonight, over-tip your waitress. Don't settle with 20%. Give 22%. Just a little extra. Let that person know that you value what they do. And when the people at Quick Trip say, "Welcome to Quick Trip," say, "Thanks." After you've had an opportunity to do a kindness for someone today, don't forget to come on back here tomorrow. Join me at the beach, and we'll talk about something else that's fun, interesting, exciting, who knows. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.